Good morning. I'm Jack Park. I'm the chair of the Professional Responsibility Legal Education Practice Group, and as the title suggests, we look at the activities of the bar and the academy. And our goal is to provide, among other things, ethics CLE, which is required by a number of the states. And to that end, we have sponsored for members an ethics CLE teleforum in 2014 and again this year, and our goal will be to continue doing that. And for the most part, we're successful in getting ethics CLE credit. I feel obligated to say something about Virginia, which is picky in the extreme. I feel like, you need to hold your mouth right and stand on one foot in order to get it. We have a great panel today on using judicial and political processes to suppress speech, and I'd like to hand it off to our moderator, Judge Steve Colleton from the interested in the activities of the practice group. Feel free to talk to me or Dean Reuter at the Federalist Society. Judge.
Well, good morning. I am Steve Colleton, U.S. Circuit Judge of the 8th Circuit based in Des Moines, and I've been asked to moderate this morning's panel on professional responsibility in legal education. Unlike many of the panels at the convention, our topic does not concern the jurisprudence of Justice Scalia. The title given to this panel, as Jack mentioned, is Using Judicial Processes for Political Purposes. Now, that is not really a fair and balanced title. I don't think any of our speakers plans to defend using judicial processes for political purposes. But in the tradition of the Federalist Society, the topic does raise some questions about which there is robust debate and two or more competing points of view. And so I hope in the course of our discussion today, the panel will display that debate for you and generate some useful discussion. Let me introduce the panel to you and tell you how we intend to proceed with the discussion this morning. Our first speaker will be Kimberly Strassel, who is a member of the editorial board for the Wall Street Journal. She writes, as you surely know, editorials for the Journal and the weekly Potomac Watch political column. She recently published a book entitled The Intimidation Game: How the Left is Silencing Free Speech. As the title suggests, the book describes the use of judicial processes and other processes for political purposes, namely to chill free speech. Our second speaker will be Patrick Morrisey, the Attorney General of West Virginia since 2012. General Morrisey was re-elected to a second four-year term just this month. Congratulations, General. And your materials set forth in detail some of the work and accomplishments of his office during his tenure. Our third speaker will be Patrick Parento, who is a professor of law and senior counsel in the Environmental and Natural Resources Law Clinic at Vermont Law School. Professor Parento has an extensive background in environmental and natural resources law. Just this year, he received the Carey Rydberg Award for Excellence in Public Interest Environmental Law. General Morrisey and Professor Parento plan, I believe, to discuss a particular use of judicial processes, at least in part, the recent use of subpoena power by certain state attorneys general to investigate whether, as they see it, corporations, in one particular case, ExxonMobil, has deceived consumers and investors with its public statements and security filings about the impact of fossil fuels or the risks of climate change. As you might know, ExxonMobil, in response, filed a lawsuit in the U.S. District Court in the Northern District of Texas in an effort to enjoin these attorneys general from enforcing civil investigative demands against them. And the district court down there recently authorized certain discovery to explore whether the attorneys general were proceeding in bad faith, such that the federal court would not be required to abstain from entertaining motions for injunctive relief. And our fourth speaker, building on that, will be Professor Arthur Hellman, who is a nationally recognized scholar of the federal courts from the University of Pittsburgh. Professor Hellman will discuss possible remedies available in the law for the use or misuse of judicial processes that chill or silence disfavored speech. After our speakers make their presentations, we will have some back and forth within the panel, and then, of course, open the matter for discussion to questions and comments from all of you. So be ready. Our first speaker will be Kim Strassel. Kim?
Thank you. Thank you for having me. It's a real pleasure to be here, in part because it has in fact always been my ambition to prove that I can be louder than a jackhammer. I also want to apologize for any of you who got up this morning to come to a book signing for me, which I was not present at. My apologies. My feeble excuse is that late Thursday night I scored an interview with Steve Bannon and spent all of yesterday doing it and missed the email reminding me to be here at 8:30. So I apologize, but we will be signing some after this panel. I think I've been asked to lay the scene here today, just more broadly, and then the experts get to enlighten you on the specifics. But we have indeed seen this incredible shift in the use and abuse of prosecutorial tactics and the judicial process to intimidate political opponents. And my argument is that while we should all be clear that this has happened many times in history before, this is not a new idea, I think we've seen an escalation of it over the past 6 or 7 years in particular. And I would trace that to the Supreme Court's decision in Citizens United, which kicked off this new fervor for using judicial processes to go after your political opponents. And here's why. Because what had happened is the left in particular had become very reliant on speech laws, campaign finance laws as a way of barring their political opponents from taking part in elections and the electoral process. When the Supreme Court issued Citizens United and struck down the big daddy of all of those, McCain-Feingold, or at least parts of it, you can actually trace a public discussion in the days that followed in which many on the left said, well, what are we going to do? It's 2010, there are all these nonprofits and other organizations flooding into the political realm because there has been a backlash against the president and his policies. The court has now said that we cannot legally bar them and corporations and other entities from taking part. We need to have a plan. And the plan that they came up with, and again, you can trace this in the literature, is, all right, if we can't legally bar them, we will do the next best thing. We will harass them and intimidate them and abuse our political power in order to send the message that they will pay a political price if they do in fact go exercise these new free speech rights. And we've seen this in many, many different realms. We've seen it in the training of bureaucrats on your opponents, which is what happened, for instance, in the IRS targeting scandal. We've seen it in proxy ballot fights in which organizations go in, buy shares, and try to force companies into passing proxies that bar them from political spending. We've seen it in harassment from sitting Democrats in the House and the Senate calling in people demanding to know what their political spending is. But I think the scariest version we have seen is indeed the rise of prosecutors and other people operating within the judicial network that use their power to try to go after their political opponents and scare them out of taking part. Probably the most frightening example of this is what happened up in Wisconsin in what's known as the John Doe probe. And just a brief background there, Governor Scott Walker, of course, passed an incredibly controversial law, public sector union reform, There was an enormous backlash from many on the left up there to that. There was an attempt to recall him and certain state Democrats from their offices. And during that recall fight, a coalition of about 30 conservative groups banded together to run ads in support of the reform. They were engaged in that electoral recall fight. Not long after, several liberal prosecutors from the Milwaukee DA's office launched a secret probe. And it's important here, Wisconsin has a very unusual law, or it did, it has since been reformed, called the John Doe Law, which allows prosecutors to engage in actions under total secrecy and imposes gag orders on the targets of their investigation. They launched a John Doe probe into these 30 different groups under the auspices of a campaign finance probe. It never really had any validity, but they continued with this. They requisitioned their targets' financial records, their emails. They staged pre-dawn raids on their homes. In one of these examples, there was a target. He and his wife were off on a charitable fundraising trip. The police showed up in the morning. Their teenage son was home alone. They came into the house in the morning dark. They put him in a room. They would not allow him to call an attorney. They would not allow him to call his grandparents who lived down the road. They ransacked the house, carted off technology and other equipment, and as they walked out the door, they informed him that if they told anyone what had happened to him this morning, that he could go to jail because he was under a gag order. We only know that any of this happened because one of the men who was a target, a man named Eric O'Keefe, very bravely came to the Wall Street Journal and exposed this investigation. We ended up writing about it. It did become national news. He subsequently filed litigation, which went all the way up to the state Supreme Court, which had to shut this probe down. And it did, and in its ruling, I think it was very notable. One of the lines it had, and I'm paraphrasing slightly, is, the prosecutors in this case have invented theories of law in order to go after citizens who are wholly innocent of wrongdoing. So it was the state Supreme Court, in essence, acknowledging that this had been a political witch hunt and that prosecutors had abused their powers in order to try to intimidate their opponents from continuing to take part in politics, potentially even jailing them. This was a criminal probe. And I think it's important, the tactics that gets used here, it's not just the threat of potential incarceration, but the entire time that prosecutors are engaged in probes like these, they are forcing their targets, for instance, to use all of their money and their resources to defend themselves rather than to be out engaging in the political process, and diverting all of their time and manpower to diverting themselves rather than being out in the political process. So there's several different reasons why prosecutors might do this if your goal is indeed to silence your political opponents. We're seeing this on a broader scale now. A coalition of some, I think, 17 attorneys general from around the country are engaged indeed in an investigation into Exxon, and more than 100 conservative groups that have worked with Exxon over the years, looking at the possibility of bringing racketeering charges for the so-called crime of not thinking the right way on climate science. While Exxon is one of the main targets of this probe, it's important to remember that also receiving subpoenas were some nonprofits. My belief is that this is being done in order to send a message to their donors that if they continue giving money to these groups that often push back on climate science, that they could end up facing legal troubles or being exposed as donors to those groups. So again, there's a multifaceted reason for doing this. The disclosure part is also important because we are seeing, in fact, many people in legal positions on the left now using the question of disclosure and financial transparency as a way of scaring their political opponents out of the political realm. For instance, up in California and New York, both of the attorneys generals there are now demanding that nonprofits that work in their states have to file with the state what is otherwise confidential donor information that is currently only retained by the federal IRS. They are claiming that they need this in order to investigate fraud in the state. That is baloney. They want this information so that, you know, then a sunshine suit gets filed and suddenly the names all go out into the public and everybody knows who's donating to these different groups and they become targets of campaigns. And just the very act of demanding this information is meant to send a message to all of these groups saying, Just be warned, your donors may have their names put out there. Just be warned, you donors, you may not want to give money to these groups because you could be outed in the end. We saw another example of this in terms of legal abuse up in New York in 2013. The comptroller there, Thomas DiNapoli, wanted to know everyone Qualcomm, the telecoms company, had given political money to. He sued Qualcomm in Delaware under its books and records law, arguing that as the main trustee of pension funds in New York, he had a right to know where Qualcomm was giving its political money and whether or not this was in any way putting the company at risk in the future, given its political donations. Qualcomm ended up settling that lawsuit and then making an agreement with Napoli that it would henceforth disclose any political contributions, even those that it's not required by law to disclose. And again, the purpose of doing all this is to send a message to companies that if they do give money, they will be exposed. They then may therefore be subject to political attacks and boycotts and questions from Congress. So this is a form of the judicial representatives misusing their power. There are many, many other examples, and the experts around me are going to be able to fill you in some more. But this is a very alarming trend that requires us, I think, to think about whether or not there should be penalties for misuse of power, to think about ways of stripping some people of their ability to engage in political witch hunts. Transparency and just increasingly being used by people with power to discourage people from taking part in elections. So, thank you.
Much, and it's a pleasure to be on this panel today. And what I'm going to try to do is really going to fit in quite nicely with Ms. Strassel's presentation, because we're going to focus on certain aspects of abuse of government power, and then we're going to dive into some of the particulars relating to the Exxon Mobil case. But let me start with an old and famous quote from James Madison. James Madison once said that liberty may be endangered by the abuse of liberty, but also by the abuse of power. We are witnessing an abuse of power right now in government that is different in kind than what we've seen in recent memory. Now, I think all of you in this room are familiar with the executive overreach and the abuse that we've seen over the past 8 years. From my perspective, there's been a purposeful intent to evade the Constitution, to disregard the rule of law, and usurp authority that appropriately belongs to other branches of government. Now, fortunately, state attorneys general have been fighting back in that effort, and we've had success defeating a number of these threats. If you look at some of the president's top initiatives, the state attorneys general were on point challenging these issues, not from a policy perspective, but from a legal perspective, because we thought that some of his actions were unconstitutional or did abuse executive authority. If you look at the Clean Power Plan, which is one of the most egregious, unlawful regulations we've seen in recent memory, we had 27 state attorneys general band together to challenge that regulation and ultimately prevail at the U.S. Supreme Court, obtaining a stay. Sadly, 4 days later, Justice Scalia passed away. But that was a significant victory against federal overreach and abuse of power. The Waters of the United States rule, an attempt to dramatically transform the regulation of our nation's navigable waterways. We were able to obtain a stay along with 30 states. Immigration, the Obama School Directive, the Persuader Rule, we could go on and on of instances where the federal government moves so far afield from their core mission, I could only characterize it as abuse of power. But unfortunately, we're also seeing abuse of power manifest itself on the state level as well. And over the course of the next few years, I think this is going to pose significant threats to our freedoms. One of the most prominent examples of that, an abuse of power, I think comes in the Exxon Mobile case. And in that matter, you have an attempt by a number of state attorneys general to punish companies with which they disagree and to chill debate on one of the most important issues of our time, climate change. Now, what I'd like to do is just unpack this for a minute, because I think once you start to see the role of the Attorney General, you can get a flavor as to just how outrageous these actions have been by some of the states. When you think of an Attorney General, you may think of a lot of different things, but there are common duties that apply to all 50 state attorneys general. Obviously, there's variance from state to state in terms of the types of functions that we have, but some of the core functions that we all know about are serving as the people's legal representative, protecting their legal and their constitutional rights. And also, most states, state attorneys general are charged with enforcing consumer protection laws, a very critical function to protect public safety and welfare of our citizens. Unfortunately, the subpoenas that we've seen over the past year conflict with those very values and those very duties that we're charged to uphold. Now, let's start with some of the issues pertaining to constitutional rights and the First Amendment. I think all of us believe, in this room at least, that the First Amendment protects people from a government that would choose to impose views on individuals or decide which views may be acceptable and which views may not. To me, that's the opposite of the role of the Attorney General. Because when I take office, and I think most Attorneys General think of it this way, we're designed to enforce the laws regardless of political affiliation or economic status. We are not the policy instruments of the state. We are the legal representatives of the people. And there is a real difference. And I would argue that all of the cases that the state attorneys general have brought in recent years have really focused on those core legal deficiencies that came out of this administration. But these subpoenas, they challenge that very notion, and they seek to punish companies for daring to disagree with the opinion of certain attorneys general in a public debate. I'm going to give you a couple quotes which to me are stunning. One investigation that came from one of the states was initiated, for instance, for, quote, the purpose of limiting climate change and ensuring that the dissemination of accurate information about climate change occurred. Wow, such arrogance. This is the stated purpose of an investigation about a topic that is subject to rigorous public debate. This isn't a debate about the law, mind you, that's coming from them. This is a debate about the underlying policy and whether you can agree or disagree with it. Now, I think all of us believe that one of the real values of the First Amendment is to spur debate. And this is particularly useful when it comes to matters of science. But when you issue subpoenas in a fishing expedition to extinguish a particular viewpoint, that obviously has quite a chilling effect on our country and the great marketplace of ideas that our founders intended to create. Think about what would have happened, for instance, if scientific debate ended when there was a consensus scientific view that the earth was flat or the sun revolved around the earth. I think science demands that we continue to ask the question and inform ourselves. And to the extent that you're going to prosecute people for having a different perspective, that can only be defined as abuse of power. It's the worst, most corrupt form of government when people charged with enforcing our liberty, defending our rights, are engaging the same actions they're designed to prosecute. Now, there are other important functions that are being cited by the state attorneys general in terms of why they're engaged in these issues. People cite, writ large, consumer protection statutes, because we are charged with protecting consumers in a wide variety of health and safety matters. We go after fraud and abuse, and we target deceptive acts and practices. Those are appropriate functions of the state attorney general. But in most situations, when you enforce your consumer protection laws, You're looking at specific evidence and whether a company is trying to induce a false claim in a commercial transaction. You're not simply trying to engage in a broad public policy discussion in order to win your point of view. That's why, when you look at this case, the issues, the material they're trying to get pertaining to research, debate, and discussion of climate change, that doesn't meet most consumer protection standards that I know about in our country. And I think it's important to look at the facts when you go after nonprofit information, where there's communication going about debate, matters of public importance, not any allegations of fraud. Those are not documents that are appropriate to be obtained by an attorney general. That's overreach, and it's just as bad as the overreach we saw with the Obama administration with many of these regulations. It needs to be stopped. Another quote from an attorney general I thought was particularly relevant. During the investigation, after a number of months have gone by, one person said, when asked about the mission, the purpose of the investigation, I quote, "We have to see what documents are in there, but certainly all the claims would lie in some form of fraud." Think about that. When you go after fraud, a lot of lawyers here in this room, do you aver generic theories of liability, or do you point out specific causes of action? I would argue you point out specific causes of action. That is not what we're seeing here. And you're seeing the investigation morph from one generally about climate change now to other specific actions to bring justification and credibility to the review. That's not appropriate. And part of the reason I have this perspective is because the timing of all these subpoenas and all these actions was quite curious. In February, all of you know that we had worked and helped lead a 27-state coalition to stop the president's signature regulation pertaining to climate change. The president's power plan was stayed. Lo and behold, 1 month later, at a big press conference in New York, many attorneys general, former Vice President Al Gore, they get together and they announce broad new initiatives and enforcement actions pertaining to climate change. The bottom line is, what they couldn't win in court, they wanted to then change and use their enforcement authority to prevail on. That's not right. That's inconsistent with the roles and the duties of the state attorney general, and that's why you had so many state attorneys general speak out against this abuse of power. But I have to note that what you're seeing now in the states and what you saw in the feds, we have to be very, very vigilant to prevent in the upcoming years. Because what happened about 10 days ago, 11 days ago, is likely to embolden certain people to continue to advocate their perspective, perhaps at odds with their core mission. So we're likely to continue to see these actions pertaining to climate change. We're going to continue to see efforts to intimidate political speech and deprive people of the ability to use their resources to communicate to individuals in the public. That's why all of us, and particularly state attorneys general, have to fight back. One of the areas that I think state attorneys general now, at least on our side of the aisle, will evolve into is to make sure that there is a check on the abuses of the other side. Because now they don't possess the executive branch of the federal government, but there are still a lot of attorneys general who possess an enormous amount of power to try to direct their viewpoints and impose them upon you. We have to make sure that there's some balance in the equation and that issues are decided through our legislative branch and through the marketplace of ideas, as opposed to through a hard directive where you're using the power of an office to effectuate your will illegally. These are very challenging times, and I think we're all going to be tested over the next 4 to 8 years if we allow abuse of authority to continue. My last point would be this. Abuse of authority is not limited to one political party or another. But I think what you saw over the last 8 years and what you're beginning to see here is different in kind. It's being ratcheted up to another level. We need to call it out even if it's easier to win your policy argument now that we're in the majority. Thank you.
Thank you, General Marcy. We'll hear next from Professor Parento.
Thank you very much. So I'm sorely tempted to defend the Clean Power Plan, but I think in light of recent events, the ultimate fate of the Clean Power Plan is somewhat in doubt. So, General Morrissey, here's a bet. I think you actually did file a legitimate lawsuit challenging the Clean Power Plan and raising legitimate legal issues that very much needed to be decided. And I don't think it was politically motivated, frankly. And the work that you did and the argument that the Solicitor General of West Virginia made, Lynn, was outstanding. So, but here's my bet. We now know that the D.C. Circuit is hard at work trying to come up with a decision in the case. My bet is they're going to uphold the Clean Power Plan, and I bet you a pint of Vermont maple syrup. I can't afford a quart. I mean, you know, we live in genteel poverty up there in Vermont. But I'll bet you a pint of Vermont syrup against, what would it be, a West Virginia ham? Pound of ham?
Well, actually, we could give you a lump of coal.
Oh! Oh, man. Oh.
Sorry, that was too easy. So.
That was a low blow. Here, I'm trying to establish rapport, and look what happened. I'll take your lump of coal and raise you 2 Vermont dairy turds. How's that for you? Okay, so one of my tasks here is to talk a little bit more generally about the use of the CID, the Civil Investigative Demand Authority that all attorneys general pretty much across the country have. I'll say a few brief words about that, and then I would like to compare and contrast 2 uses of Attorney General CID authority, both of which do relate to climate change, which I think we'll stipulate here is actually happening. I won't ask for a show of hands, but let's just stipulate for now that it's actually happening, it's real, and it may be serious. CIDs, they are really very, very broad grants of authority. There's no doubt about that. And although there are procedural mechanisms to challenge CIDs and try to quash them in the sense of quashing a subpoena, the procedural rules and the burdens of proof that attend attempts to try to stop a CID-type investigation are extremely limited and largely worthless. Now, those could be tightened under state law, of course. You could make it harder for these CIDs authorities to be used. They could be circumscribed. You could empower courts to intervene more actively. You could do lots of things, but as they stand across the country, they're very, very broad grants of authority. The Supreme Court in the Morton case basically said they're akin to a grand jury proceeding, and all you need is suspicion. You don't need probable cause, reasonable cause, suspicion. And in fact, it's enough to just satisfy yourself that something illegal isn't going on. So they're incredibly broad authority. Now, the 2 examples that I want to cite to you are, one, Ken Cuccinelli's use of a CID to go after the noted climate scientist Michael Mann. Some of you may know that name in this room. He's the author of the infamous hockey stick, showing the very dramatic rise of CO2 emissions post-industrial revolution and the corresponding rise of average global temperatures with all of the implications that science, 97% of scientists say, are happening. So Mr. Cuccinelli decided that because Michael Mann was a professor on the faculty of the University of Virginia, getting grants for the University of Virginia to do his climate research, that he was going to open an investigation against Mann. It turns out that of the 4 grants that he was going after, only one of them actually was a grant that went to the University of Virginia. But as to that grant, he proceeded to press forward with his investigation. Michael Mann, of course, resisted, but more importantly, the University of Virginia resisted. And the University of Virginia went to state court seeking a declaratory judgment to enjoin the investigation by Ken Cuccinelli. It turns out that that Cuccinelli's premise for the investigation, similar to Schneiderman's premise for the investigation of Exxon, was fraud, was consumer fraud. Well, it was actually fraud on the state by getting grant money that was being used for illicit purposes. And what were those illicit purposes? To to phony up the data on climate change. So it was a direct attack on man's integrity as a scientist and his use of the data that he was generating through these grants. Well, the lower court in Virginia agreed with the University of Virginia, dismissed, in effect, the investigation. Cuccinelli, not to be outdone, renewed it, changed it a bit, came back at Mann and the university again, and this time it went to the Virginia Supreme Court, which said there was absolutely no basis for the investigation and stopped it cold. The moral of the story is the University of Virginia spent $350,000 in taxpayers' money to defend its scientists against a clearly illicit and improper use of CID authority by Attorney General Cuccinelli. Now, let's contrast that with what Schneiderman and Healy in particular from Massachusetts are up to. And here I am going to levy some criticism on what the way they're going about this. So Schneiderman has subpoenaed Exxon under, of course, the Martin Act, which is the strongest and first securities law in the nation. New York has the strongest securities law on the books. It's also a consumer protection law, but its central focus is protection of investors, with Wall Street just being down the street, so to speak. And where did Schneiderman get the idea? Well, maybe it was because of what happened with the Supreme Court stay on the Clean Power Plan. But it also was because there was an investigation disclosed by the LA Times, by Inside Climate News, that in fact Exxon had known for a very long time, since back into the 70s, that climate change was happening, that fossil fuels were causing it, that they were measuring the effects, that they were reporting the effects, and that they were actually, Exxon was out in front of most of the scientists of the world developing hard data, empirical data, on what was actually happening to the Earth's climate systems, ocean systems, and other impacts. And so, in addition to that, there was a case brought against ExxonMobil by the village of Kivalina in Alaska, which is being forced to move as a result of sea level rise and the melting of the Arctic and the breakup of the pack ice around their barrier island and so forth. They sued Exxon seeking damages, a common law claim under federal common law. Unfortunately, in the meantime, the Supreme Court removed federal common law, as many of you may know, in the AEP case. But when the case was brought, AEP hadn't been decided, so there was at least some basis for a federal common law action for nuisance against ExxonMobil, seeking damages to move the village off the island, which is disappearing. During the course of that litigation, several documents came to light from ExxonMobil's activities with a coalition of groups opposing climate policies and talking about climate science. Allegations back and forth about what these documents show. Are they smoking guns? Are they something less than that? Point is, there were documents that were disclosed through that litigation. Schneiderman interviewed the lawyer for Kivalina, Matt Powell, a friend of mine, by the way, avid, crazy environmental public interest lawyer, by the way. And maybe Mr. Schneiderman shouldn't have interviewed him. Maybe that didn't look very good in the public eye to be talking to a party of interest. But nevertheless, Matt Powell did have information that Schneiderman's office used. So based on that amount of information, the subpoena was issued. Now, I've got the subpoena. You can read it if you want. It's real clear about what they're after. They're after two things. Number one is stranded assets. And this is the core issue about fossil fuel reserves on the books of many corporations. About 90 corporations own most of the fossil fuels on Earth that are on the books. And the question is, can they burn them all? Can they use them all? Or are they going to have to do what the climate scientists and 196 nations of the world have said in the Paris Agreement, not burn them all? How many can we burn? Those are big policy questions that we're not going to resolve here today, I'm sure. But the point is, the question is how much of the risk that those assets on the books of companies actually can't be used if you meet what the climate change objectives of this agreement, or what the scientists are saying are necessary to avert these catastrophic consequences. So that's the main thrust, and go ahead and look at it. That's the main thrust of Schneiderman's subpoena and Healy's subpoena in Massachusetts. They're directed at Exxon. They're directed at the stranded assets question. Second question they're asking is, why aren't you writing down the value of your oil assets in light of what's happening to oil prices on the global market? All the other oil companies in the world are doing that. Exxon's not. Why aren't you doing it? Now, you could say, this is just a politically motivated endeavor. But the fact of the matter is that Securities and Exchange Commission has opened a parallel investigation on both points and are pursuing exactly the same track as Schneiderman and Healy are in their investigations. But here's the thing. The attorneys general did get together and have a press conference with Al Gore. That was a huge mistake. That was a stupid thing to do, in my judgment. Why do that? I mean, if you've got a legitimate investigation and you're grounded on state law and you're focused on a narrow range of questions, why not just let that play out and let the facts say what the facts are? And when the investigation is done, report the findings of it. This is a civil investigation. It's not a criminal investigation. It's not leading to a RICO indictment. Maybe somebody will try to bring a RICO case as based on it, but that's not what the subpoena is saying, and that's not what Schneiderman is pursuing. Now, Exxon went to court in North Dakota, I'm confusing the waters of the U.S. rule, went to court in the North District of Texas, and Judge Kincaid did a very interesting order, read that too, basically say, in light of the circumstances of this press conference and the apparent collusion, if you will, cooperation of all the attorneys general, and the banner being climate change and let's save the world, I'm kind of troubled by what is happening here, and I'm going to allow discovery, jurisdictional discovery, on the question of whether or not, as Judge Colleton said, the federal courts should use younger abstention and refrain from intervening and let the state processes play out. So this discovery process, which may include depositions of Ms. Healy herself, is underway. I don't think that was a thing that needed to happen. I think the attorneys general have brought this on themselves and probably raised legitimate questions about why they're doing what they're doing, and they didn't have to do that. So I also want to criticize what the Attorney General of the Virgin Islands did, Mr. Walker. Now, he jumps up and says, well, our island is most at risk from climate change, which is, certainly true. Island nations are in big trouble. But what the heck is the Virgin Islands doing jumping into the middle of an investigation of ExxonMobil for securities fraud? And, of course, Exxon turned around and sued Attorney General Walker, and he quickly beat a hasty retreat, settled the case, and dismissed that. So these attorneys general have certainly raised questions about their motives. They've certainly raised questions about the way in which they're going about discharging their public obligations to investigate if they believe there's serious securities fraud, consumer deceit. They didn't need to do that. They should not have done that. And I'll close by saying now it's spinning even further out of control. So now Lamar Smith is conducting oversight hearings, and he's issuing his own subpoenas to the attorneys general, demanding that they come forward with information about why they started this investigation. He's also issued subpoenas against nonprofit organizations like the Union of Concerned Scientists. So this miasma now of the politicization of subpoenas over climate change, to me, is a total distraction. We don't need this. We need serious debate about how we're going to deal with this challenge, what the prospects for clean energy are, what the costs and benefits of those kinds of technologies. That's where the debate should be. And are these predictions of scientists legitimate or not? Let's debate that. We should have climate skepticism. We should challenge, claims about what's happening, and we should demand proof of that and peer-reviewed evidence of that. That's where the debate should be. Instead, we're fighting about whether or not these subpoenas are legitimate or not. I don't think that serves the national interest. I don't think that moves us forward on a really important issue. Thank you.
Thank you, Professor Parento. And Professor Hellman, we'll hear now from you.
Thank you, Judge. In his great concurring opinion in Whitney against California, Justice Brandeis reminded us that those who won our independence rejected silence coerced by law, the argument of force in its worst form. That's what we're talking about here today, efforts to coerce silence through law, not through statutory enactments like the California Syndicalism Act that was at issue in Whitney, but through the use or misuse of judicial processes. You've heard about some of these efforts today, the Wisconsin John Doe investigation and subpoenas issued to scientists and energy companies in the climate change investigation, and maybe I should add now the Cusinelli investigation. But in the American legal system, the force of law is also available to private parties. notably through the means of libel suits. And climate change again provides the example, and this time Michael Mann, the meteorology professor, was the plaintiff. He filed a lawsuit against commentator Mark Stein, National Review, and others. He asserted claims of libel and intentional infliction of emotional distress based on statements posted on the National Review website that criticized his research in harsh terms. For example, the writers characterized the hockey stick graph as fraudulent and Mann's work as intellectually bogus. By the way, that suit was filed in 2012, and it is still pending. As Mark Stein has said, the process is the punishment. I'll have more to say about that in a moment. Now, people can, of course, disagree, and we've heard disagreement here about the merits of particular cases. But the instances are numerous enough and serious enough that we can say that there is a problem. Instead of competing in the marketplace of ideas, people confronted with speech they don't like are using the courts to shut down the marketplace. My task on the panel, I'm the wonk here, is to address the question, what can be done about this? You'll have observed that these cases arise primarily, almost exclusively, in state courts, and I'll limit myself to those. I'll discuss two possible remedies at the state level and two at the federal level. About half the states have already recognized that litigation can be used to stifle free speech, and they've enacted what are called anti-slapp laws. SLAP, with two P's, stands for Strategic Lawsuit Against Public Participation. Anti-SLAP laws provide for the speedy dismissal of meritless lawsuits that seek to impose liability based on speech or other conduct that is protected by the First Amendment or a state counterpart. Anti-SLAP motions are brought at an early stage of the litigation, and what is particularly important, discovery is stayed absent permission from the court. So as the California court has said, the defendant may test the sufficiency of the plaintiff's claims before incurring the costs and disruption of the pretrial process. But anti-SLAP laws have a number of important limitations. They do not apply to criminal prosecutions or to civil enforcement proceedings brought by the state. And even in the realm of private civil lawsuits, anti-SLAP laws can be undermined by unsympathetic judges. That's what happened in the Michael Mann suit against Mark Stein and the National Review. The D.C. Superior Court recognized that the various statements involve matters of public concern, and also that Mann is a public figure, so he has to show knowing falsehood or reckless disregard of the truth. The court even acknowledged that language like intellectually bogus and scientific misconduct used on a website devoted to opinion certainly appear as exaggeration and not an accusation of fraud. Nevertheless, the court held that when one takes into account the accusations made over the years, the statements somehow turned into factual assertions, and the court denied the anti-SLAP motion. It's particularly troubling that in holding that the defendant's statements were based on provably false facts, the trial court relied on the fact that several bodies, including the EPA, had investigated Mann and determined that his research and conclusions are sound. The notion that a statement about science is false because some governmental body has said so is about as antithetical to the First Amendment as you can imagine. Still, for all their limitations, anti-SLAP laws can play a substantial role in limiting the use of the judicial processes to suppress speech. Another possible remedy at the state level is through regulation of lawyers' professional conduct. Now, that's something I probably wouldn't have thought of a few years ago, but this past summer, the American Bar Association approved an amendment to the model rules of professional ethics bit here that would subject lawyers to discipline if they engage in discrimination, which includes verbal conduct that manifests bias of the kind that the ADA doesn't like. As Eugene Volokh, whom you'll hear from later today, and others have pointed out, the disturbing breadth of this rule, if adopted by the states, could lead to disciplinary proceedings that would actually fall within the ambit of this panel today. My point here, though, is that if disciplinary rules, attorney disciplinary rules, can be used to advance societal goals like the elimination of bias, also be used for other social goals, for example, to counter the misuse of legal processes to suppress speech. I'm not going to hold my breath, though, for that to happen. So let's move on to possible remedies at the federal level. Right away, I'm on dangerous ground talking at a Federalist Society convention about federal court intervention in state proceedings. But as Senator Cruz said yesterday, our lodestar as Federalists is the Constitution, and one part of the Constitution, the 14th Amendment, authorizes Congress to enforce rights secured against state action, and that includes the incorporated provisions of the Bill of Rights. So I'll talk here about two possible remedies, removal and federal injunctions. Congress could authorize removal to federal court of state court proceedings that threaten interference with federal constitutional rights. In fact, it may be that Congress has already done that. The statute, section 1443 of the Judicial Code, authorizes removal of civil suits or criminal prosecutions by any person who is denied in state court a right under any law providing for the equal civil rights of citizens. Half a century ago, legendary law professor Anthony Amsterdam published an article arguing that Section 1443 should be interpreted to allow removal whenever a substantive federal civil rights defense is asserted. Well, the on his article when the Supreme Court entirely rejected that approach, worst thing that can happen to a law professor, and instead interpreted Section 1443 very narrowly, so as to leave almost no room for civil rights removal. That's pretty much where the law is today, although I should mention that the House Judiciary Committee is considering a bill to create a federal anti-slapp law, and one section of the bill would allow removal from state court in cases that would be subject to an anti-slapp motion. Has some real drawbacks as a device for limiting abusive state court litigation. And in particular, removal brings the entire case into federal court, even though only one part of it may raise constitutional questions. A more targeted remedy, and the final one I'll be discussing, is one you've already heard a little bit about today, the federal injunction. And here Congress again has acted. Section 1983 authorizes a suit in equity by anyone who has been deprived of federal rights by someone acting under color of state law. Once again, though, Supreme Court decisions have narrowed the reach of the statute in a way, as a way of holding state court proceedings that violate federal constitutional rights. To summarize a complex body of law, it is theoretically possible for a federal court to issue an injunction in those circumstances, but as a practical matter, very difficult to get one. The Wisconsin proceedings provide an example. Federal District Court in Wisconsin found that the John Doe campaign finance investigation that Kimberly has described did violate First Amendment rights. The court issued an injunction ordering the state prosecutors to cease their activities and destroy the copies of material they had seized in the raids we've heard about. But the Seventh Circuit, in a unanimous opinion by Judge Easterbrook, held that principles of equity, comity, and federalism foreclosed the injunction. Eric O'Keefe and the Wisconsin Club for Growth asked the Supreme Court to review that case. They had some very powerful amicus briefs on their side, but the court denied review. Meanwhile, we have the subpoena proceedings in the ExxonMobil case. We'll see how that turns out. Half a century ago, the American Law Institute proposed that Congress should explicitly authorize federal courts to issue injunctions against state court proceedings in certain civil rights cases if the very existence of the state court proceeding was such that it had a chilling effect on others who exercise federal constitutional rights. I think it would be worthwhile for the Senate and House Judiciary Committees in the new Congress to explore the possibility of enacting legislation along those lines. The legislation won't be easy to draft, and the federal injunction is not something that should be used very often. But there will be occasions when it's the most effective way of assuring that state judicial processes are not being used to coerce, silence the argument of force in its worst form. Thank you.
Thank you, Professor Hellman. We'll maybe have some feedback from the panel, and if anyone has questions or comments, we'd be happy to entertain those too. Having heard from the experts, Kim, do you have any reaction and see any hope for relief?
I don't see fascinating idea for very discouraged in Wisconsin to watch what happened at the Seventh Circuit and to thought and probably in orders in order to get the federal judiciary involved in some sort of restraint in some of these things. I had an interesting reaction, though, to your point about the legitimacy of these subpoenas with regard to stranded assets, because my problem with that is that it could be an excuse to go after any company for, in essence, anything. I mean, I could make a pretty good case right now that, you know, maybe some prosecutors ought to get together and sue all of the biggest beef processors in the country on the argument that they may be committing consumer fraud, because the likelihood that a new president is going to come in and issue an executive order saying that you can only eat Trump steaks is really high. So, you know, isn't there a question then of stranded assets? I mean, couldn't you just use this argument for anything?
Oh, you probably could, but the difference with carbon is that there's very real prospect that these fossil fuel assets are not going to be used. And that's not just coming from Greenpeace. That's coming from Goldman Sachs. The window on coal is closing and so forth.
But isn't there a very real prospect that we will only be able to eat Trump steaks?
I hope not. I grew up in Omaha, so you know what steaks I eat.
General Morrissey, what is your reaction to Professor Hellman's suggestion about legislation that might allow for limited federal intervention in state attorneys general proceedings and the like?
Well, I think with many of these ideas, it all depends upon the perspective you're in. Obviously, when the citation was made earlier about Attorney General Cuccinelli pursuing something and there's perceived abuse there, and then the flip side, we're citing the Democratic Attorneys General. I think it all depends upon your perspective and what is the solution of taking it up and removing to federal court going to result in a substantive solution, or, you know, I don't know. I'm not convinced that that's going to get you anywhere other than to have a different set of people review it, but I'm open to it.
Well, just add to that. I was talking about procedural remedies. I agree with General Morrissey that the first thing to do is to think about the underlying substantive rules and what the limits are on subpoenas or other activity.
Can I add one other thing I would add that I think is worth everybody remembering is that this is much broader than just directly attorneys general, for instance, taking action or state prosecutors taking action. If you look at, for instance, what happened in the IRS targeting scandal, we're talking there about bureaucrats, but of course the reason that this was so scary to so many nonprofits out there is that for the average American, they associate bureaucrats with the power of law enforcement. You know, many of the people who received these notes from the IRS saying, you can't have your not-profit status, here's an 80-page questionnaire that you need to fill out. The thing that struck them most heavily was the fact that every one of these letters from the IRS began with the words, under the penalty of perjury. And they were being asked to fill out this questionnaire. And the thing that went through most of these people's heads on an immediate basis was, are these folks out to get me? And if I write anything on this questionnaire the wrong way, am I going to end up in jail because they don't like my politics? And it was so scary to many of these groups that, of course, many of them revoked the paperwork that they had filed with the IRS and ceased attempting to get nonprofit status. So I think it's just important to point out that the power of the judicial process is not necessarily limited simply to those that can bring actions directly. It is to the extent that whenever you have an agency, a federal agency or a state agency, and there is knowledge that there is prosecutorial power backing up that agency, they have the ability to intimidate and harass opponents as well, too.
Do we have any questions from the audience or comments? Yes, sir. Would you mind identifying yourself and then...
John Vecchione of Cause of Action. Particularly the Wisconsin situation and some of what we're hearing today, has anyone looked at the solution of weakening prosecutorial immunity for some of these cases, and would that have an effect?
Well, Professor Hellman?
Well, that's certainly one proposal that has been floated at this under current law, which is judge-made law, applying common law principles under Section 1983. The Supreme Court has held that prosecutors have absolute immunity, not simply the qualified immunity that other government officials have. This, by the way, is another one of those areas where Congress could act. The Supreme Court has handed down these rulings as an interpretation of what it thinks Congress was doing when it enacted Section 1983 back in 1870. So Congress certainly has power to do that, and that's another area where I think it would be very useful for Congress to hold some hearings, see what should be done, if it should be something less than absolute immunity, how you qualify it, because you don't want prosecutors to be facing the threat of personal liability and damages when they act in the way General Morrissey is described in the public interest and are going after some company.
So just to add to that point, obviously one of the challenges that we have is that there's always a fundamental imperfection with the system. Because at the end of the day, all of us rely upon the prosecutor to exercise good judgment and to make decisions that are in the best interest of the people and to be an administrator of justice. The challenge you have is that, once again, making changes or making it easier to go after the prosecutors cuts both ways. For instance, we have situations in West Virginia where we've had to enforce laws and we've been sued by different people in our personal capacity. And I could see scenarios where that would literally drain you dry and you would not be able to even uphold your basic duties because they can get you caught up in litigation for years and years. And obviously then we have the notable situations of abuse that we've all heard about it, whether it involves Senator Stevens or issues down in Texas or the matters we're talking about today. So the dilemma I face, and this is why the way I reacted to the previous question, is every time you create a new system in order to address the perceived failings of human beings, it's going to cut both ways. And I don't know how you develop a new system to bring out the better angels. This is where the public dialogue comes in, so there's adequate pressure to make sure that you have the right people in those positions. I'm not sure there's a process solution to them. That's just from my position, because in West Virginia, when I was the only Republican in the executive branch, I was subject to one frivolous suit after another because I was the only one articulating my perspective. So when I hear positions that make it easier to do that, to engage in that, in those harassing tactics, I'm a little bit skeptical of that. So, but it all depends upon the position that you sit in. And I think we have to be careful about creating new mechanisms in order to try to get to a preordained result.
One other solution to this, too, or not a solution, but a way of addressing it, is also better crafted, more tightly crafted laws.
Oh,
And
yes.
you probably have thoughts on this as well, too. I mean, one of the greatest tools for any rogue prosecutor is a sweeping or vaguely written law. This is what we saw up in Wisconsin. The campaign finance law up there was such a disaster, such a mess, allowed for so much to be done under it that the prosecutors in that case were able to gin up what was really a totally bogus investigation into these people. We had reference to the Martin Act, which some people look at as it's wonderful that it has such sweeping powers, but I think we have seen how it can be abused as well, too. Interestingly, after all of the abuse did come out in Wisconsin, the state legislature there did two things. It reformed the John Doe law and it reformed the campaign finance law, in part because it wanted to make sure that the openings there were not available to future prosecutors. And that is something worthwhile thinking about at the state level.
Yeah.
What about the scope of the civil investigative demand authority under state law? Professor Parento mentioned the breadth of it and how it's akin to grand jury authority. Would it hamstring the attorneys general if that were narrowed in some way?
Well, interestingly, in West Virginia, we have a higher standard set for when we can issue a subpoena, and when we engage in an enforcement action, they set a standard of probable cause from when we can obtain material. That's a pretty high barrier. And so sometimes it's very difficult, and it's obviously different than other states where there may be just mere suspicion or reasonable certainty. So I think there actually is some variance across the states. Ours is particularly challenging, but then again, part of the reason why ours is more challenging is because there was a pushback against my predecessor Attorney General for using subpoena power in a way that was perceived to be abusive. So it, once again, depends upon what position you're sitting in. But I do think it's always beneficial to have a higher standard, because at the end of the day, these are individuals that are going to be subject to prosecution. They may have to expend enormous funds in order to defend claims that may or may not be true. And so having a reasonable certainty standard or a probable cause standard, I think, is better than the alternative.
I will say that the Martin Act has been challenged multiple times. There's a huge body of law on it. It's been challenged on First Amendment grounds, Fourth Amendment grounds, state law grounds, overbreadth, unreasonable, vague, and they've all been rejected. And the Martin Act investigations, all the attorneys general in New York have used it over the years. And to my knowledge, there's never been any finding, at least by a court of law, that there's been ever illicit use or improper use of it. I mean, you can certainly argue that some of the uses of it were, quote, improper or politically motivated, but I'm not aware that there's any sort of definitive ruling that's been used improperly.
Oh, yeah, and I'm not suggesting that a court find it. I'm saying that, it would behoove state legislatures to go back and look at some of these laws. And I have no doubt that the Martin Act probably does allow the prosecutors to do what they're doing here. I think the question is whether or not we want laws that therefore do allow them that kind of latitude.
Yeah.
Yes, sir, in the back.
A quick comment and then a question
Do
to
you mind
Professor
identifying yourself? We can't see very well.
Parito. Sure, I'm sorry. I'm Hans von Spakovsky from the Heritage Foundation. You're talking about climate change, but no, the claim is man-induced catastrophic climate change, and no objective review of the evidence can come to the conclusion that this is anything other than an unproven scientific theory, not a given fact. But my question to you is this. The latest
Baloney, okay?
Well, it's not. It's
That's
an unproven. It's an unproven scientific theory, and you're trying to criminalize.
Are you a scientist? Where's your peer-reviewed literature?
I am. I'm one. I'm a scientist.
Well, show me your peer-reviewed
Well,
study that discounts the 97% of scientists who've concluded
I will.
otherwise.
I will.
All right, hold on.
Here's
Order.
my question.
Hold on.
On to the
hold
law.
Okay.
All right.
We can't afford this kind of baloney.
The latest theory.
All right.
Okay.
The latest theory that
Let's
the
have
New
a-
York,
let's
the
have a
latest,
question.
the
Let's
latest
have a
theory that the New York Attorney General has come up with to justify his investigation that we've discussed is that ExxonMobil committed securities fraud by overestimating the oil reserves it has in the ground, which it'll be able to get out because future changes in regulations will prevent it from getting that oil out of the ground. However, my understanding of SEC rules is that when ExxonMobil is estimating its oil reserves, it has to do it based on current laws and current regulations, and that it would be committing securities fraud if it based its estimates on oil reserves on what it speculates future changes in those regulations will be. So how in the world can the AG of New York justify its investigation when ExxonMobil is following current SEC rules on estimating oil reserves?
Well, you'll have to take that up with the SEC and ask them why they opened an investigation on that very point. They do have carbon disclosure guidelines. They're alleging that ExxonMobil has not shown compliance with those carbon disclosure guidelines. They're asking ExxonMobil, did you see what just happened in Paris when 196 nations committed to reducing global greenhouse gas emissions by 80% and going to carbon neutrality in the second part of the century? Do you not think that that's a reasonable risk to the assets of the company to disclose to investors?
What I think is they have to comply with what the current regulations are in the United States, not a
That's
theory.
not true. Look at the guidelines.
Not a theory about
true.
what the changes are going to be in the future.
Not true. Look at the guidelines.
If I can,
Thank you for the question.
if I can weigh
Yes,
in.
hold on. We're going to hear from General Morrissey on this.
I think one of the issues this reveals is when you look at these debates, this is a panel that's looking at judicial excess and looking at abuse of power. And what frequently happens is exactly what happened right here. You're going to have a robust debate on policy matters, but the reason why the Attorney General of West Virginia and many other of us, when we're engaged in climate change litigation, don't get into the bowels of the discussion on the science is because this is a debate about the law, and it's a debate about the use of the tools to effectuate your policy preference. So I think what you saw here is actually why it's so critical for state attorneys general and the judiciary to actually stick to the law, because you can always come up with a policy idea that overrides it. And that's the great lesson, I think, of the Clean Power Plan litigation, and I would argue why there's been excess from the other state attorneys general.
Patrick, you wish to comment any further, or should we take the next question?
Well, I was responding to the policy point that was made, right? So I agree with you about the law as a separate inquiry, and whether or not the courts can decide whether or not Schneiderman and Healy are out of bounds. That's where that belongs, not in Lamar Smith's hearing room. It belongs in federal district court, New York district court. It's going to the New York Supreme Court now on the question of whether or not Schneiderman has exceeded his authority. If he has, he should be slapped down, and the subpoena or the CID should be quashed. I have no problem with that whatsoever.
We have one question in the front, and then we'll come to you. Yes, sir.
Hi, Jefferson Knight, president of the Miami Federal Society. How big a leap is it from investigations of ExxonMobil to investigations of my friend Hans? It seems to me it's not a very big leap at all, especially when you have professors shouting at hands basically to shut up. Isn't this very serious?
Here, say it again.
In abridged form, if you can.
How big a leap is it from investigations of ExxonMobil to investigations of my friend Hans? Basically, he's saying what a lot of us in this room are thinking, which is this is pure bunk. And the impulse of some people is to shut him down. How big of a leap is it to think, well, maybe one day Hans and myself are going to be investigated?
We've already had this happening. Look, there are various professors that have been branded climate deniers at universities across the country. They've been harassed and sent letters from Senate Democrats. Their universities have been required to hand over documents to Congress to sort of justify the work they do there and their emails. There are 7 of them. They've received subpoenas for stuff that, well, actually not subpoenas, just requests for what they're supposed to hand over. But, you know, these are campaigns by some of the most powerful officials in the country in order to send a message to these professors and those who employ them. If you continue to employ these guys, you're going to get harassed by the federal government. And you're going to have to spend a lot of time sending us, you know, the process is a punishment. You're going to have to spend all of your time spending us, so maybe you want to rethink whether or not you want these guys on your staff. And we're going to make your lives hell as well, too, and demean you and publicly sort of harass you, intimidate you. Now, this is not a lawsuit. It's not litigation. But it is definitely a campaign, again, stoked by the highest levels against people for the crime of thinking differently than those particular senators think. And I think that is hugely concerning. We do have examples, too, of actions that have been taken against individuals. There was a very well-known businessman who gave a large contribution to Mitt Romney's super PAC back in 2012. The President of the United States and his campaign team went through financial disclosure records, found this guy's name along with 7 other very large donors, put their names on their campaign website, accused them of, in essence, being criminals, of being anti-American, of being bad people because they were supporting Mitt Romney. Within a couple of months, this businessman had the IRS visit him. Then he had the IRS visit him again. Then he had the Department of Agriculture do an audit on his ranch. He had, in Idaho, Frank Vandersloot. And he essence, went on TV and said, look, the President of the United States put a target on my back by naming me and shaming me and sending the message to every federal bureaucrat, this guy's a legitimate target. I'm your boss and I don't like him. And so, you know, he spent several years being harassed by the federal government. It's a very concerning turn.
Question in the back. Yes, sir.
My name is Ronnie Sams. I'm a petroleum engineer, attorney from the great University of Texas A&M. Actually, I'm going to maybe put a little levity in this thing. I'm an investor in ExxonMobil. I've done business with ExxonMobil over nearly my whole life. But I think we owe the environmentalists and the other green types to the predecessor company of ExxonMobil, Standard Oil. Because in August of 1859, a train conductor went and drilled a 60-foot well in Titusville, Pennsylvania. You know what he did? He saved the sperm whales. If you will go to the museum in Hawaii, you can see a can of sperm oil in the biggest port that the whaling ships used to come to. You can read Moby Dick if you want to. But sperm whales are thriving
Alive.
because we do no longer use a can of sperm oil to put in our lamps in the age of illumination. We now use some form of natural gas, coal, crude oil, etc. Now, I don't want to say what my qualifications are, but I took lots of courses in thermodynamics, historical geology, paleontology, so maybe I'm not a climate expert. But I would, under thermodynamic principles, question whether how much, whatever we call it, is the result of man-made fossil fuels. But the other thing is, if you want to fly to get here, if you want to drive to get here, if you don't want to drive a wagon, if you don't want to ride a bicycle, you're going to have to use fossil fuels in the near future.
Okay. Any other questions from the group? I'm not sure. Was that a question? Did I miss the question?
Mark Venezia from Center for Individual Rights. This is a question for Kimberly Strassel. hopefully you didn't cover this already, but are the IRS discriminatory actions, what the IRS did back several years ago, is it still going on?
Yes. No, it's terrible that this doesn't get more attention. So actually, just last week, the IRS rejected the nonprofit status of the Albuquerque Tea Party, which was the very first group that had been put in isolation, and it's been waiting for 7 years to hear back from the IRS on whether or not, and suddenly no comment, no reason why the IRS rejected its nonprofit application. There has been a federal court in recent months that has suggested that targeting may be continuing at the IRS in terms of groups that they are segregating out and not giving nonprofit approval to. And of course, we have never had anybody held to account in the entire thing. Now, there are several lawsuits that have been filed again in federal courts, so there may still be some sort of fines or penalties levied on the IRS in the end, but we're still a long way from there.
Thank you.
Yeah. By the way, I want to add one thing that I do agree with Patrick wholeheartedly. What happened to Thomas Mann was wrong. Thomas Mann, Michael Mann, Thomas Mann too, as well. But mostly to Michael Mann in this situation. That litigation against prosecution of him was incorrect, not just because it stifles free speech and academic debate, which is so important, but also because there are other remedies for things like this that don't require prosecution, and we all need to keep this in mind as well, too. If people did not like the fact that Michael Mann was receiving state or federal grants for his work, then change the grant rules. Make a campaign for why certain types of research doesn't deserve funding. But sicking prosecutors on someone because you don't like their research, I think, is more problematic.
All right. We might have time for one more before lunch here, if we have any takers. Yes, sir, in the back.
Yeah, Matt McCusker, Convinced Litigation Consulting. I'm going to avoid how many carbon we put on the head of the subject, but I'd like to ask, I've been personally involved in 2 cases where what looked like the playbook was the judiciary and the media, but it was at a state level, where an individual first was sued to get removed from a ballot on a very esoteric interpretation of being qualified, was taken off the ballot, and then the media just pounded. The local media pounded over and over for months and months until it went to a more liberal Supreme Court who dragged their feet and then said, okay, we're going to put you back on, but there's only essentially 60 to 90 days left. No campaign happened, no fundraising happened. Essentially, the campaign was killed. Had another case, very similar in the fact that an individual was targeted by a political practice commissioner who had been with Ralph Nader back in the 80s forming community groups and targeted this individual for the suggestion essentially that taking campaign contributions of $300 and then voting for something in favor that this political practice commissioner said was really not in the best interests of his constituents was pay to play. And that turned into a significant case. And what ended up happening again was punishment. And in both those cases, the judiciary didn't kick it out. It got to keep living. And the media pounded and pounded during the time of that going on. And the question is, what do you do about that?
Well, as a public official, I have a very direct answer to that. Under state law, many states still are constrained with the limits on campaign contributions. Let's be very clear. Many of these media outlets, they're corporate owned, they have their own agenda. When you have the constraints on individuals' ability to fight back at $1,000, for instance, in West Virginia, or $300 in Montana, it's going to make it very difficult to compete with an entity that is going to be hell-bent on pushing their perspective. The best way to compete in our constitutional republic is through the marketplace of ideas, and a candidate should not be hamstrung to tell his or her side of the story, in contrast to the media that has unlimited amount of money to push their agenda.
All right. Any further comment on that point, gentlemen? We'll
Just
Well,
have strong perspectives.
We have one more question. I think we can fit it in. Yes, ma'am.
That's true.
Once reasonable people hear your arguments, it can change minds. I didn't get rid of the league. You just help this band to units.
That's great.
Please join me in thanking our panel for their presentation.
I enjoyed it. Thank you. I look forward to staying in touch.
Yeah, you did.